a municipal court administrator can declare probable cause on her own volition. A police officer in the street can declare probable cause. There's no adversarial process there. A grand jury can establish probable cause. There's no adversarial process. But somehow, in Bergen County, New Jersey, the law was bent to the will of a special defendant. Judge McGeady held a probable cause hearing. And at that probable cause hearing, Governor Christie was represented by counsel. Counsel wanted to cross-examine me at that hearing, and Judge McGeady said, this is not an adversarial proceeding. Your client is not yet a defendant. Your client has no right to cross-examine a witness at this stage of the proceedings. After probable cause is found, if it is found, you will get a notice of court date, and at that court date, you will have all rights and privileges of defense counsel that would attach. But right now, your client is not a defendant. This is not a critical stage of the proceedings. It's not an adversarial proceeding. The probable cause can be established just like you did and just like was the process in Bergen. The governor, who appointed the Bergen County prosecutor, who appointed the Attorney General of the state of New Jersey, then got the Bergen County prosecutor and the Office of Attorney General to agree with him that I should have been subject to cross-examination. The defendant here was the Attorney General of the state of New Jersey at one time. He is a seasoned and trained attorney. He's represented by one of the most high-profile litigators in the state of New Jersey. Everything that Mr. Genova seeks to do for his client is appropriately done as a defense after the charge has been found and made. Right now, he's trying to defend a client who's not a defendant yet. This man, this defendant, was treated differently than every other criminal in the state of New Jersey thus far. He extorted millions of dollars of a personal benefit, and he threatened to withhold official action if he didn't get that millions. And he is not going to serve a day in jail. He's making legal arguments based on what I presume he's going to present case law. And if I'm here as a pro se litigant, and I don't have the guiding hand of counsel that he's saying he needs to have, and he's going to make legal arguments on behalf of his client, then the appropriate time for him to make that legal argument is when there's a trained prosecutor to make a counter-legal argument, not before, when the citizen stands before you, not as an officer of the court, but as a citizen complainant. What he wants to do is argue against the citizen instead of the sovereign.
Thank you, Your Honor. Let me focus on the central question that you raised. First of all, what we're here for today is to ask for an adjournment. And Your Honor is accurate in describing that our request for an adjournment is to put before the court reasons why we think, in this case, the process that you described as the typical process is inapplicable or is otherwise so amorphous as to allow the kind of application that we seek to make and at least brief to the court as to why. So let me first start with the process. When you go to the court rules, the municipal court rules at 7:2-2, it talks about the process, and it talks about the process that Your Honor talked about, but it's also silent on a lot of things. It gives us no direction as to the role of a prospective defendant, because we're not a defendant yet, not until and unless a probable cause determination is made. And it's as powerful in the absence of its direction as it is in the gray matter and the amorphous instruction that it gives. And what's particularly compelling here, whether or not probable cause can even be issued when it's predicated on an allegation that is identical to an allegation that's already been prosecuted and resulted in a conviction in a federal jurisdiction. That's one. Number two, there's a whole question of Mr. Brennan's standing to even invoke the laws that he would characterize as a citizen complaint, when on the face of this and the submissions that I've seen today, he offered nothing to the court that indicates any personal knowledge upon which a probable cause determination can even be made. So it's clear that he is seeking to bootstrap and to duplicate and double dip, if you will, on the identical allegations of which he has no personal knowledge that I've heard him say, or in any indications that he said. He has no personal knowledge. He may even have bias, because we know him to be a candidate for public office. A New Jersey probable cause hearing I'm going to pause. The New Jersey probable cause hearing is a preliminary hearing at which defendant should have been represented by counsel. In future cases, therefore, counsel must be appointed to represent defendants. We have an individual, a citizen complainant, who is a self-appointed prosecutor who is attempting to hijack a prosecutorial system, apply it for his purposes, and do it in a manner that he simply bootstraps on a prosecution that already took place and was forged and advanced and prosecuted by the executive branch of government. Those determinations should be made at the inception rather than to allow a process to continue, to have a probable cause determination knowing full well that there's no legal foundation for the ultimate prosecution, and go through the charade of this exercise to advance what appears to be a political agenda of this complainant. I'm not here to cross-examine Mr. Brennan. I'm not here to ask him any questions. I'm not here to argue the underlying merits. I'm here to ask the court to give us the opportunity and the space to properly put these issues before the court, because they have significant impact on my client. They have significant outcomes on my client, who's already been convicted of a federal crime, is already serving a sentence.
The one harm of official misconduct is meant for the higher standard of proof and the higher standard that we hold public officials to. And bribery and extortion apply generally to everyone. And that's why there's a longer statute of limitations for official misconduct than there is for most every other statute. And that's why there's a mandatory 5-year minimum term of imprisonment for official misconduct. And under bribery statutes, you can spend a year in your vacation home. But on the facts that we are here to talk about, he is a public official. He did commit an act that was an unauthorized exercise of his official function. It was to obtain a personal benefit, and the value did exceed $250. That's what's properly before us. This is a smokescreen designed to do something that's not appropriate for this forum. His client isn't going to languish in jail. He hasn't been prosecuted under the same statute in another sovereign, and the statute I am prosecuting him under has a different remedial effect and a purpose than the one that he was convicted of in the federal court. And justice has not been served. And any reasonable person can see that going to your vacation home for a year is not equal justice under the law.
Except for Justice Linares, the Chief Judge of the United States District Court, who felt in the application of the sentencing guidelines that justice was served. The ludicrousness of the arguments that are being advanced here and the rhetoric, Your Honor, should not go unnoticed on the court. So many things were said by Mr. Brennan that are inaccurate. I feel compelled, and if Your Honor will indulge me, I want to go through each one of them. And I want to reinforce with Your Honor, we're now getting into the merits of the argument that I would like to ultimately have, having not had the benefit of doing the kind of briefing and analysis that I would like to present to the court. But I will, because Your Honor's asked those questions, and I'm as prepared as one can be in 18 hours. By the way, I thought the Constitution said life, liberty, and the pursuit of happiness. So the focus on liberty, yes, Mr. Samson is subject to house arrest, but I do think, like even any other felon that's been convicted, he still is afforded rights under the Constitution to which they applied, including the right to counsel in appropriate circumstances. And bear in mind, Your Honor, the United States government invested 3 years in an investigation here, of which several prosecutions emanated, this being one of them, and convictions resulted. Having everything that's in this indictment, or at least allegations of it, and having all the evidence that was sufficient to get those convictions, and no choice was made either by that agency, the United States government, or by the Attorney General of New Jersey to prosecute on an official misconduct.
Official misconduct is one of the most pernicious crimes that you can commit. It is the reason that we call New Jersey what we call it, the armpit of the justice system. People don't believe in the rule of law in New Jersey because official misconduct is not prosecuted by state and county prosecutors when it comes to people who have power, who have influence. Official misconduct is a broader, more inclusive statute that does not require you to have engaged in bribery or extortion in order to reach the level of conviction that requires that mandatory 5 years of imprisonment. I cited People versus Coons in the Rodney King beating. I said it was People versus Coons and the United States of America versus Stacy Coons. He was a police officer for the Los Angeles Police Department. He was on videotape brutally beating an African-American man, and he was found not guilty by a jury. Those same identical facts and that same videotape was used as evidence in a federal criminal prosecution that resulted in a civil rights violation. Official misconduct is different than bribery. Civil rights is different than assault and whatever the statute that he was charged under for the brutal beating that he inflicted upon Rodney King. They were the same facts, different sovereigns, different statutes. Again, that's why this is not identical. It's not analogous. It's a 7-year statute of limitations versus a 5-year statute of limitations. It is a 5-year mandatory minimum with no early release, no parole, no probation, no pretrial intervention. It is a specially designated statute that is distinct in every way from extortion and bribery, which I am not charging here. The elements here are different and the purpose is different. This is to send a message to like-minded public officials that they should not engage in official misconduct because the penalties are severe. It is sending a different message to different public officials for different reasons, and that is the very language of the statute Mr. Genova brought to you that I looked up on my phone, and he is not saying that I misquoted it. He's not saying I mischaracterized it. He's now going to mischaracterize it. I can tell by the way he's standing up that he's going to say that what's written here means something different. I know, but it's not the role of this court to be engaged in this kind of motion practice on a probable cause hearing, and that's what Your Honor, what's happening here is that this defendant is being treated differently than every other defendant in the Newark Municipal Court, in the Essex County Municipal Court system, and it's not appropriate. And the fact that it's happening again for this individual. It's not on you, but they're raising all kinds of issues that are supposed to be raised once the man is a defendant. This is a defense that they're raising. They're raising a defense before he's been charged, and that's not appropriate.